Well, welcome back everybody. It's time to restart our morning briefing. The second speaker this morning is Mitch McKenzie. Mitch, I won't tell you when he was admitted to practice, but he's coming up for 10 years having signed the bar roll. Mitch was articled at Doyle & Kerr and eventually became a partner in that firm. Later that firm merged and he became a partner in Tolhurst, Druce and Emerson for 4 years. And he's been at the bar since 2005. It broadly does all types of commercial work. His principal areas of practice are wills and estates. He did the celebrity case of Peter Brock's estate about informal wills, where he won for the children. In a TFM case, he had a recent win where $400,000 was received for a 9-year-old in the Whitehead case, and the estate of Samson in September 2011. Mitch also practices in real property. VCAT decisions with his name on them include Dawson and Gallant Valley in May 2008, a jurisdiction for equitable interests in VCAT decision. In 2011, Sutherland against Corkill, co-ownership and accounting between owners. He also deals with sale of land, including off-the-plan sales and default issues. Also does retail tenancies and, of course, owners' corporations matters. There are numerous VCAT decisions in which Mitch has appeared. He graciously admits not all have been favourable in his case, but he's happy to appear on the winning and the losing side. He'll argue the case for anybody. Has acted for institutional clients ranging from various religious groups and charitable providers to developers and legal practitioners to ousted tenants and excluded family members. These days, Mitch mainly appears in the Supreme Court and VCAT, but he will appear in the Federal AAT and Magistrates Court and County Court from time to time. He's regularly in mediations in all areas and including before the Small Business Commissioner. Mitch's talk is going to address VCAT and some current issues, so I'll hand you over to Mitch.
Good, thanks Bill, appreciate that. I better have another look at that stuff. Some of it was a bit odd. I don't want to go and stand up there. I've got bits of paper all over the place. I take the view that the wisdom is in the room, and I'm very happy if someone says, well, what about this, what about that? So I just listed a set of topics that I thought were current, that I hope are going to be of interest, and I hope that we can talk them through a little bit. Just with Bill talking about where I go and what I do, I've got a case starting tomorrow. It's already run for 3 days, a VCAT case, and some of the players are in the room, some on my side. We were setting the hearing for tomorrow, and Senior Member Vassie said, how would today suit? And I had a look and I said, yeah, that'll be all right, I'll finish my Moorabbin Magistrates Court matter. But my opponent, QC, said, I'm in the High Court that day. So we're on tomorrow. While I'm talking, let me just mention that High Court matter. I hope I don't get to it because I hope there's more going on before we get to it. But there has been a High Court matter that popped up last week, fairly hefty judgment. Brookfield Multiplex and the Owners Corp strata plan such and such. It's a New South Wales based case that got to the High. Quite like the idea that we're here on Owners Corp, and Owners Corp tends to be a little bit of a side water, and you go down to VCAT or you do this, you do that. Well, we've been to the High Court on Owners Corp now. I had, and you'll see this in the last little bit of my paper, paragraph 5, High Court deals with Owners Corp matter. No duty owed to the Owners Corporation for defective work. Now, in the handout, you have received the little one-pager that the High Court Registry sends out. As you can see in the way my paper's presented, I say Brookfield Multiplex, Bill Stark to explain it in his blog. Bill does run a blog. It's a very useful property law blog, and every now and then Bill and I have a chat about some things that should appear and shouldn't appear and where we're going with that. But that Brookfield case, I have had a look at it. I tried to prevail upon Bill to talk a little bit about it, but it really says that in this case, Brookfield Multiplex didn't owe a duty of care to the owner's corp to build the building without defects. And you sort of go, that doesn't seem right. But when you look at it, this is a very complex judgment, and the builder and the developer had an absolutely watertight belt and braces deal. And of course, then there were mistakes. They weren't able to be claimed for by the developer. And the owner's corp came along and said, I have a statutory duty to look after the common property. I've got to put it in good repair. I've got to keep it in good repair. And you should have done this better and made a claim. And the High Court have said, no, not going to let that happen. It could probably be very much confined to its facts because there are 2 or 3 elements to it. I don't understand, and I'll make some further inquiries, why it is that the purchasers didn't make a claim rather than the owner's corp, because one of the things that was said was the day the owner's corp sprang out of the inkwell, the developer owned all the units. The developer owned and managed the owner's corp in that sense and then employed a manager. So the High Court were really saying, this is still you, the developer, and you've got to deal with the builder. And then for the owner's corp to come along and say, I want special favours, you should have thought about me when you built in this manner. The High Court said, no, I'm not going to let you do it. The history was, owner's corp got up and got knocked out by a single judge, won in the Court of Appeal in New South Wales, which was a strong court, said there was a duty owed to the owner's corp, and then knocked out again in the High. I think I'm not sure we'll see a lot more of it, but it's an interesting case. So, having spoken about that, the other thing that I was going to mention just apropos of the High Court was I was reading a document which said, it was talking about the High Court, and in fact the reference was to a past judge of the High Court. I think several of you might well be able to identify this judge. I'll tell you the quote. They're talking about His Honour. He had a tendency to look past the law for what he perceives as just outcomes. This was typified by his attitude on the doctrine of precedent, which he described as, quote, eminently suitable for a nation overwhelmingly populated by sheep. This is Lionel Murphy, in case you don't recognise him. Lionel just decided what he thought should happen and then tried to figure out some logic that followed with it. I don't think this is going to be, that Brookfield is going to be a major precedent in the owners' corp area. So, let's get down to the really exciting stuff. Section 32, non-functioning owners' corps and the current rules. It's a bit of a relief, I suppose. I was a solicitor for far too long, as Bill made clear, and then came to the bar. But doing those Section 32s and mucking around, particularly with owners' corps, when you say to the client, tell me this and tell me that, and they say there is no owners' corp. Well, yes, there's always an owners' corp. It may not be functioning. It may be in deadlock. It may be this, it may be that. Well, now Section 32, thank God, says you can just say under Section 32F that the owners' corp is inactive, and then if you specify that, that relieves you from the otherwise very onerous obligation. So I thought it was an interesting interchange where we got the Owners Corporation Act that then called up the detailed owners corp certificates in Section 151 that called for provision of all the prescribed information, fees payable, that's old fees, fees and charges imposed or proposed to be imposed on a lot. Bit interesting, proposed to be imposed, because you get those quotes are out, they're going to fix the roof, they're going to jack up the sagging underpinning on some floor somewhere, and is that a fee proposed? Do you need a fee? If you've just got the quotes and you haven't accepted them, is there a fee proposed? Is there going to be a levy? Is it coming out of the maintenance fund? So a lot of that sort of stuff floats around. I have spent 2 half days so far going through a series of Section 32s to do with a unit and 2 associated car parks, and I'm quite confident that the Owners Corp certificate is fatally flawed, and that the Owners Corp certificate doesn't produce the right stuff. We've ticked the boxes. Does it have this, this, this and this? What funds are held? What are the liabilities and contingent liabilities? What are the contracts, leases, licences and agreements affecting the common property? The one that comes to mind when I talk to you like this is that they had a minor licence agreement referred to, but they didn't have the agreement with the Owners Corp manager. On first blush, I think the Owners Corp manager's agreement is an agreement that affects the common property because it's the Owners Corp manager that is in charge of and responsible for managing the Owners Corp property, the common property, and therefore that's an agreement that ought to be specified. But we're going through it with a fine-tooth comb. I think we've got about 25 points. I think something in the order of 6 of them are sufficiently material to knock out, and I think the whole thing in combination means that we'll get a walk on it. But that's what people are doing in these circumstances. So the Section 32 documentation paper that I'm talking about, there are a couple of particular issues that I wanted to talk about. One was the reliance on the statement the Owners Corp is inactive. The way I read Section 32F, it says you must provide the information prescribed under A, and then that's basically all the stuff, or attach the statement. I'm not sure, and I'm interested if anyone's had an opinion on this, whether if the Owners Corp gives you a flawed statement and you've put it in your contract, is that gone? No, me. If the Owners Corporation has given you a flawed statement, you put it in your Section 32, you can rely on the provision in the Owners Corp Act that says under Section that if you have a certificate, that's sufficient. But if the Owners Corp certificate doesn't have everything that it should have, who picks up the tab? Can the purchaser walk? Is it your responsibility to have checked it to see that the Owners Corp got it right? Or do you just, when all hell breaks loose, you go to the manager who didn't get it right, who didn't put in the stuff? More questions than answers from me, I'm afraid. I think I've said on several occasions the wisdom in these meetings is in the room, and every now and then someone says, I did that, or we had that, or... I haven't seen an Owners Corp, I haven't seen a Section 32 as yet which says it's an inactive Owners Corp. But I remember over the years I dealt with a number of instances where I would have been greatly relieved to be able to just say the Owners Corp is inactive and walk away. So no doubt it'll take a little while. Yeah, shoot. There's a roving microphone somewhere. Brett's going to rush down and it saves me having to then repeat the question and get it wrong.
I guess it's just more of a comment rather than anything else. In doing the Section 32 statements in relation to an inactive Owners Corporation, I think you've also got to be wise to the idea as to Section 11 of the Sale of Land Act as to disclosing the requirement to have insurance when selling within an Owners Corporation. Therefore, if you advise your risk-adverse vendor that he really should have the required insurance required for that particular Owners Corporation, being public liability for common property or reinstatement or replacement, not insurance, then there may never be a true inactive Owners Corp if they go out and get the required insurance.
So that's a nice question. Thank you for the comment. That's the sort of thing that I appreciate and I think is helpful in a morning like this. 32F, the new section, says a reference to an Owners Corp that is inactive includes an Owners Corp that has not in the previous 15 months. So inactive is inactive across the board, but it includes, and then it says an Owners Corp that has not in the previous 15 months had an annual general meeting. Happens. Sometimes they haven't, they're pretty ineffective. Or hell breaks loose and they fixed any fees. So it's had an annual general meeting and fixed any fees and held any insurance. So an interesting question, if you go off and get some insurance, the Owners Corp doesn't do it, you know that you need some cover, you've got your unit and you go and get some of that top-up cover from one of those places. They're not so easy to get, well they weren't when I was last doing it. So you have cover. Does that mean it's not an inactive? It's got to be those three things together. Not an annual general meeting within 15 months, not fixed any fees within 15 months and not held. So it's the Owners Corp that has to hold the insurance. I doubt in the situation that you're you're contemplating that it would necessarily be the case that the owner's corp held the insurance. Probably the purchaser or the vendor would, because they'd top up their current cover for their unit. But again, some interesting problems arise out of that. I suppose all I wanted to talk about was how you do it and what you do and how you go about it. I will make some reference later, if I get to it, to some other non-functioning owners corp. I'll talk about it now. My client owned lot 1, significant lot fronting a major road, let's say Warrigal Road. A strip of land which was common property ran to lot 2, which is a significant property up the back. The owner of lot 2 subdivided into 16 lots, 16 warehouses, and sold them off the plan and sold them off, not settled yet. Won't trouble you with the details. Some people around know what I'm talking about. The upshot of it is that in order to get that subdivision through and to service the areas at the back, the common property had to be changed because the council required that, and it was regraded, resurfaced and everything else, but without consent from my lot owner. No big deal, I suppose. They're going to go and regrade it, put up this new road. The trouble is that the road, it was on a slope, there's a gradient, so up the top where it enters the back, lot 2, the entry to lot 2, it's probably 2.5 metres above where it was. Otherwise it sort of rambled in and there were different things, but the structure now means that lot 1 can't have the use and enjoyment of the road. So one of the things that's going on is we called upon the vendor to notify all the purchasers of his lots, the lots up the back, that we're at VCAT saying this road has been built on common property without the appropriate special resolution. It's a significant change, you know those rules, significant change to common property, need approval, no special resolution. Been a big fight about the planning permit. Planning permit was, yeah, we told everybody. Well, you didn't. Didn't tell us, didn't tell the owners corp, didn't this, didn't that. Oh, well, you've now seen the plans, yeah, but they don't have the elevations and didn't show us that we would have a lack of access onto this road as it gradually crept up to get to where it's got to be at the back. So those sorts of things are rumbling around, and who's going to come out right and who's going to win, all a bit interesting. But it's nice and simple, Section 32, say this, say that. But when you start to unpeg it, all those things are rumbling around. I make that comment there, 1.2, what if the owners corp has a certificate but it's old? Reference in the paperwork is attached to the Section 32 a copy of the current owners corp certificate. Current, I love that. The most recent. So we've had this discussion, if you've been here before you've heard me say this. My view is that Section 32s don't get stale. I've heard people say, oh, if it's over 3 months old, it's stale. It's not like a use-by date. It's stale, it's not current if the information's wrong. If the information hasn't changed, you can get a Section 32 that's 8 months old. But if the information's right, it's right. At the time you give it, if it's relevant and pertinent, then it's good. If the information's changed, well, it's no good. And keep your fingers crossed, because usually people don't find out. It's very rare that someone comes in and we have the fight about whether we can get a Section 32 point up. But when we do, they're dynamite. That's probably all I wanted to say about Section 32 stuff. Happy to talk about it or perhaps take some questions. I hope to finish, I was going to say, a bit early so that we can have some questions if there are some. The second topic I've got is the application of the VCAT jurisdiction to share company titles. That's it's one of those sort of strange areas. We have the benefit of being involved in this case for 3 days that I talked about with the silk on the other side. The issue really is that there had been a row about a no pets rule in a fairly substantial building, which was a share company building, and the particular person complaining about that was very unhappy that she couldn't bring her little dog in, and she actually, as we saw when we read Hansard, got the law changed, because share company titles you end up having to be in the Supreme Court. What a pain that is. How much time and money you've got to do if you've got to go to the Supreme Court because it's a company matter and it's your shareholder and you've got to do all that stuff. Oppression, anyone remember those lectures? Well, She got the law changed after we hammered her a bit about the pet, and the law now says neighbourhood disputes arising in share companies go to VCAT. So we're down at VCAT. She got the law changed. She's the first person to bring the case. We've had 3 days in front of Senior Member Vassie, and we've got 2 more coming up tomorrow and the next day. They don't come across your desk very often, but when they do, it's nice to know that you can slip on down to VCAT and run it against the silk for 5 days. I'm sorry I said that. I then talk a little bit about discrimination at large, and of course it's most of the barristers who give these talks do this. You do a case and you have a look and you try and sort out what's going on. So what I had already run the case of Metro and the Owners Corp Kelly, which was one where, you know, the ongoing row about whether you can stop people doing this and stop people doing that in the units. And the one that's been rumbling for a long time, and you're all aware of it, is short-term owners, short-term occupiers. So owners have it, they put in short-term occupiers. My first involvement with this was with the Rialto building, where there are several owners who are happy to have short-term occupants, and of course short-term occupants come in for a weekend and a long weekend. Quick list, hens parties, bucks nights, card nights, disco nights, and dropping as many bottles off the balcony into the courtyard as you can. And it seems that the other owners don't like it much, keeps the kids awake. So is there some way to stop short-term leases from the owners who are doing it like that and making that a business? The Metro case was one where what happened was there was a rule. It's quite an interesting case on the rules and sub-rules and when you need a special resolution and when you don't. But the upshot was the complaint was short-term renters, if they wanted to use the gym and the pool facilities, had to have an induction. OC Health and Safety. OC Health and Safety, yeah, we've got to do that. So inductions were every Monday between 9 and 11. And of course, short-term renters come down and they're there from Friday midday through till Monday midday. They could get inducted in their last hour of departure or something. So it was said this was discrimination. The case is quite interesting. Roland deals with the discrimination issue, and it's, the way she framed her order was quite interesting because she said, I'm satisfied that the rule itself is probably not correct because you should have passed a special resolution, although you did it through committee and you did it under a subheading of the rules which says if you need to have OC Health and Safety rules, you can tack those in. You know the way those things work. The upshot was that she then said, I'm satisfied that the way of implementing the induction to use the pool and the gym area is discriminatory because it doesn't offer enough to meet the needs of those people who are short-term renters, because they're not going to come in and stay for 3 or 4 days or do this or do that and go through this induction to learn how to use the gym equipment or not to try and breathe underwater or whatever you do for pools, I'm not sure. Maybe don't run, don't drop your champagne glass in the pool, and those sorts of basic rules. So she ended up saying, unless you come back, she made an order saying the rule will not apply unless the Owners Corp and the manager come back with a proper basis upon which for OC Health and Safety this must be done and why it has to be implemented in this way. We haven't gone back.
About the pets issue, because that comes up.
Pets issue. Well, that's the next one, 3.3. SAF and ZON, because dealing with my no pets rule matter that we've run for some days, in SAF and ZON, without even the need of changing the law, having the Supreme Court jurisdiction over share companies, some poor little fellow, Mr. Saf, brought a claim to say he was being discriminated against by the manager of his particular share company operation because he wasn't allowed to keep his cat. Sad case when you look at it, and I shouldn't be jocular about it. Serious depression, very, very unhappy man, and felt he was being picked on. And it's quite interesting because in that one it was Judge Howard as Deputy President, Judicial Officer, and a very well-reasoned judgment, but it was a strikeout application, and this application by SAF got struck out because the no pets rule was said to be a proper and reasonable rule. It was in the books. It was when you bought your shares and got your unit, paid your money and had that, you were told about it. And he had a running row. He was warned, he was warned, he was warned. First cat died. Second cat he bought, shouldn't have done it. And he just said it wasn't fair. But he hadn't said he suffered from huge depression. He had thought that a medical certificate had gone to the management. And in the end, Howard just says, look, the rule itself applies across the board. It's not discriminatory. The real argument seems to be that it shouldn't apply to him because he's different. He didn't tell everybody he was different. And I'm not going to let him go on with this. And he struck out the claim. Discrimination, that was under these sort of different ranges of things. So let's go back to how that works, probably where your question was going. That was under the equal opportunity and anti-discrimination legislation. And there's a series of guidelines in that. The discrimination issue in share companies is that there's a specific clause, section 13 of the company share title, whatever the word is, legislation, I hope I've said it somewhere, which says if a particular rule of the company is discriminatory, it's null and void. So prove it's discriminatory, it's gone. There is another, that's of course one limb of the matter that I've been arguing. The other limb is that if there is a resolution of the company which is oppressive, unfair, etc., then that can be struck down. And that goes to, let me call it the exemption issue, where someone says, I want to be exempt, because, of course, the arguments always are, anybody want to have a go? The seeing eye dog, the blind person with the dog, companion animal. Or, of course, there's also the goldfish. No. All right. So there's all those things hanging around.
How are those issues relevant to the fact that there's full disclosure? These are the rules. Just don't buy it. That's not else.
Yes, I tend to say something. The question was, why are we having a fight about no pets? If it's no pets, it's in the rules. It's there, and they actually sit down and tell you that. And the answer is quite often that the people, Mr. Saf and perhaps others, aren't well. They weren't thinking it was going to be a problem, but it is a problem now. So how would it work, for example? Let's pick it up and steer clear of going too close to the case. Elderly lady, knew no pets, progressively blinder, finally needed a dog. Well, as it happens, there's special rules which say that guide dogs are exempt and you can bring dogs onto public transport if they're guide dogs and this and that. So there are some exemptions hanging around, but there are changed circumstances. And somebody who perhaps has a particular attachment that derives later, then they come and make their complaint. The other case I mentioned there is Owners Corp. I've just had the 5-minute note, so if I start to talk faster and my voice gets higher as we go through. Rhodes was Ian Lulham, a senior member down at VCAT. That's gone now? Yeah, still there. Rhodes was one where there was a rule which just said no commercial use. It was a combined premises, bit of a hotel, some hotel associated retailing, and a lady ran a beauty or pet shop business. Eyelashes, eyebrows, something or other. I don't know much about that stuff, as would be apparent. The upshot is, because the rule applied to everybody, it was a very simple matter. Ian Lulham just said, look, the rule was there, you knew about the rule, you can't carry out the business, bad luck, no. That was great. I said it to Member Rowland when I did Metro, which was the gym and the induction one, and she said, oh, yes, oh, you know, we've had a bit of a chat in the tea room about that from time to time, we don't all agree with him. What? Sounds a bit like Lionel Murphy on precedent, doesn't it? Oh, sorry, there's no precedent down at VCAT. They're not bound by each other's decisions, but I must say I'm looking at Roland's comment. Roland does a detailed argument, and Rob Hay was against me in that one. It's one of the ones that Bill's mentioned that I lost because we didn't get to keep it. In SAF and Zon, we got Howard, judge, saying his bit, and he was spot on, and he analysed it very well. But of course, under the discrimination legislation, OC and Roads, I had a look at it again just to freshen up for this morning and for tomorrow. And the upshot is that that was run by the beauty salon person herself and somebody from the OC manager. So it's a question of why Ian Lulham found it able to hit it over the fence in a matter of probably 5 pages, whereas Metro goes quite a long, Metro's a fairly lengthy and reasoned judgment, and she didn't knock us out. She said, come back with an OC health and safety reason, and you come back with an OC health and safety reason, and you'll be able to have these inductions, but you'll probably have to tinker it so that the short-term people don't get discriminated against. Saf and Zon, Judge Howard was very careful and looked after this person very well, and a very well-framed decision. Meetings, notices required and the acquisition of common property. Well, this touches on another matter that I was involved with, where the retirement village out in Knox, the decisions there, Knowles and the Owners Corp. What really happened was there was a discrete building on a separate patch of land, and of course there's common property and lifts and things within it, and the owner of that building wanted to redevelop it, and of course didn't want to have Owners Corp tied up in it, so therefore wanted to just take over the common property. Fair enough. And they had a bit of a liaison with another major owner in the show. Fair enough. That meant they could do what they blooming well liked, so they could get a special resolution through, sweet as a nut. And then what they did was, because they were under pressure for planning or building reasons and there was some time limits hanging around, they went bang bang and said, well, we're just going to acquire it, and this new subdivision comes through and the common property vanishes and it all becomes ours. And we put our little hands up and said, doesn't seem fair. And Vassie said, yes, it's really not fair, and I'm not going to let them do it. But he worked through how it should work. There were issues about the notice calling the meeting. Vassie spent the first 2 days telling myself, Nick Payne and Tiffany Ackerman, who does a lot of this sort of work, were opposed. And he said, I'm not interested in all this server stuff. But then when he handed down his decision, he said, on reflection, gentlemen, having looked at what you do, because I'm now voting in place of those who voted against, and I have to be satisfied that I can and should vote that way, then I probably have to be satisfied that they've been properly served. And he got some interesting stuff about service in there, showing how to do it. I haven't quite caught up. James took me by surprise because I got the impression that Conrad or something else, or some changes to the Act, might mean all that hard work and all that knowledge that I've acquired is out the window now. You don't have to bother with these meetings and special resolutions. Bill gave me a 2-minute, is it 2 minutes before questions? Yeah, about time. Any questions, please? For me, James, or Bill, particularly about High Court cases. Shoot. Just wait so I don't have to repeat it.
I've got a client who bought a unit in a block of flats in Chirac a year and a half ago. There was a solicitor in the building as well and a member of the Owners Corporation. There was the same big argument about pets. My clients were in their mid-80s. They had a small pet, and we had an argument before settlement, and they told us that we were allowed to have a pet, but when that pet died, we couldn't have another one. Now, I looked up the rules and I couldn't see anything in the Owners Corporation Act which says people can't have pets, but there are rules to say that there can't be pets can't be a nuisance on the common property. So no one knows what the law is. Does the Owners Corporation Act say that pets are excluded?
No.
I don't believe that there's any specific exclusion of pets in the Owners Corp Act.
That was my view. So I said to my clients, their pet is now 15 years old, pretty close to death. And they rang me last week and they said, if our pet dies, can we get another one? And I said, yes, you can. I thought you said there'd been a great arrangement. Can I just ask, Lindsay, you said, did you say something about pets? No? All right. I just thought you reacted and I thought you might have come across it. Yes?
I actually, in looking for a unit for myself and my wife, we've got 2 dogs, and one of the things we're looking at is that very question of pets,
yes.
Units, common property. There is nothing in the Owners Corp that I can see that excludes pets. You'd have to have a proper resolution, a proper something else.
I think it's quite clear that If you want to moderate the current model rules to include a rule that says no pets, then you have to go through the proper process, and then anyone buying would be on notice, and they have to get the 75% and go through it properly.
Would that be consistent with the Act that says here there's nothing to say that you can't have pets? Now, the rules can be inconsistent with the Act, and if the rules are inconsistent, they're invalid.
No, I think I should say this. I don't think there's any reason why you couldn't have a situation where there was a resolution passed that stopped a range of things, and changing the rules in a range of ways is a regular matter that goes down to VCAT. I've done them, James has done them, and they get down there all the time. So, and I don't think, somebody asked me whether they could change the rule to say no short-term leasing. And I said, I think that's outside the ambit of the Owners Corp rules, because the Owners Corp rules is mainly to do with using and enjoying common property. If you've got your own freehold, how they can stop you using your freehold, then I'm happy with the goldfish. I'm not so happy with the elderly cat. Who knows what's going to happen with Princess the dog in the next little while. But the upshot really is, so long as the rule is geared up around use and enjoyment of common property, so you've got, one of the issues is, let's be clear about it, if the dog's being taken for a walk in and out, you can't just keep it in your unit, and you're then on common property in the lifts, walking through the garden, being told to come back with your plastic bag in hand if you need to, those sorts of things.
Excuse me, in my case, my clients don't have to go through common property, they've got direct access on the Toorak Road from the unit.
That sounds good to me. Any other views? Any other questions? Are we done? All done? Everybody's got a point? Oh, sorry, Julie. Those who have to wander can wander, of course.
My question relates to the issue about can you make rules in relation to the use of car parking lots. One of the things that has been asked of me, not that I'm working in that space directly, is whether the Owners Corporation can prevent short-term leasing of the car park, because there are a lot of security issues in car parks, and cars get broken into, and access into the common property actually compromises the security of the building and to the other residents. And I wondered whether anyone had come across that.
Good question. Thanks, Julie. James will deal with. Hospital hand pass.
My understanding of the present legislation, and I think it might differ in this regard from the Subdivision Act, is that there is a degree of power on the part of owners' corporations to make rules that do affect the usage of private lots. So I think it would depend on the specific circumstances and whether or not the leasing to third parties that were not members was causing a sufficient problem to really warrant the making of that rule. But it's certainly a grey area. Under the Subdivision Act, as I understood it, the rules had to be geared around usage of common property or effect on common property, hence the old rule about pets and the nuisance on common property. That's why that was geared in that way. But in theory, I believe under the new legislation you could pass such a rule. The question would be whether it was struck out by VCAT.
Can I just add my tuppence worth? If you read Metro, you'll see that when we tried to have the induction problem saying people can't this and can't that, she said the implementation is discriminatory, but if it's for a purpose which is OC health and safety, common property and those sorts of things. So I think that's going to be the way forward to that. Find out why and how, and for a good reason you probably can stop the short-term leasing if it's, as you say, seriously interfering with security and those things. Time, gentlemen, please.
All right,
Thank
if we could just thank Mitch in the usual way for his talk.